the News Channel 5 network, this is Morning Line with Nick Barris.
Good morning, everyone. Thanks for joining us on Morning Line on this Wednesday. Nick Barris here, and good show on tap for you. We haven't seen this gentleman for a while. It just seems like it's been a bit, and I'm glad he's back on. He's a regular guest, of course, here on Morning Line. We're going to talk about, I guess, malpractice. What happens medically if you have an issue with a doctor or a hospital or the like. And it happens a lot, and it's real important you know what your rights are one way or the other if you suspect something was done that wasn't quite on the up and up, and how quickly you need to move on it and what the issues are. And for that, no one's better at telling it than Clint Kelly, malpractice attorney.
Good morning, sir.
Good morning. Good to see you.
Yeah.
I don't know why. It seems like it's been a while. Maybe I missed you. I know you come on every month, but I haven't seen you in a while.
Had a vacation, spent some time out of town,
out and about.
Now I'm back, ready to roll.
No, it's good to have you on. It's good to see you. You're looking rested and ready to rock. And yeah, listen, we'll open up the phone lines in a moment, 737-7587. But just again, just a reminder, as you know, when Clint comes on, he specializes in malpractice. That is all you do.
That's right. I'm board certified in medical malpractice. Been doing this for almost 26 years.
And your father did it.
He does too. He's been doing it for 35 years. So let's see, we're a combined 60 years of experience together doing this, and he's board certified as well.
Well, and board certified means
that we are specially certified by the American Board of Professional Liability Attorneys to do medical malpractice cases. We have to have a certain number of jury trials. Sure. We have to pass a verbal exam. We have to be recommended by other experts in the field. Once you go through that process, you take a written test, and after that, they will certify you if you pass the test. Okay.
Now, we get new viewers to Morning Line every single day, and so some may be joining us for the first time. I guess if you can, just give folks out there a primer on what is the definition, how they would know to look for whether or not they maybe have a malpractice case.
Sure. It's a major medical mistake that causes a major medical injury. Typical injuries that we take: death, amputation, brain damage, paralysis, a loss of eyesight, something that will compromise the patient's ability to earn a living, racks up giant medical bills. Frankly, cases, Nick, that juries will look at seriously and say we would actually fine against a doctor in a situation like that, versus a lot of other cases where the injuries are just simply not bad enough to justify a jury finding against a doctor.
Yeah, I guess what you're saying there is there can be cases where you've been done wrong, but if the damages aren't great enough, there's not a whole lot you can do. Hopefully, and you should be glad you weren't severely damaged. The key phrase that, and I've learned so much from Clint over the years that he's been on, I really have. You could be a great professor, but standard of care.
Yes.
Because how do you define? The truth is, you're going to go to the hospital sometimes, and the results may not be the best, and doctors are not miracle workers. They do the best they can. So when you say mistake, I know you mentioned that. How do you determine whether or not a doctor made a mistake in something like that?
Nick, the best way I know to explain it is there are mistakes and there are bad mistakes.
Okay.
Mistakes are cases in which the doctor complied with the standard of care, but a bad outcome occurs.
Okay.
There are times when doctors do the best they can, but the injury is so severe, or there was an alternative treatment that the doctor considered but didn't go with that turned out to be the right treatment, but the doctor made a reasonable judgment in doing what he did, and unfortunately you had an injury. But then there are bad mistakes, and that's what I call a violation of the standard of care. That's where the doctor broke the rules. And there are rules to his profession, just like there are rules to our profession and your profession. Sure. And when he breaks those rules, and as a result of that, a patient is severely injured, that's what's deemed a violation of the standard of care, and that's what gives rise to a medical malpractice case.
Yeah, and the standard of care is, what is typical that most doctors do, and what is accepted in the field, right, as being the proper way to handle it. And if they didn't meet that threshold, then that's an issue.
That's correct, and they're the ones that decide what the standard of care is, that being doctors and experts that I hire that judge what those defendant doctors or hospital staff, what they've done to commit malpractice.
Yeah, if you have a siren song on this show, it's that you lament how the laws continue to change and make it more difficult for the patient to sue. It just seems like it's still going that way.
Nick, I think maybe the pendulum has begun to swing back the other way. Let me give you an example.
Okay, good.
We've talked, you and I have over the years, about the tort reform that passed in the legislature in 2011 that put caps on damages. And a lot of people don't know, if you're severely injured, whether it's a malpractice case or a car wreck case, And let's just say, for example, you're paralyzed. The law imposes a cap of $1 million on non-economic damages. That means if you're stuck in a wheelchair, all you can recover are your medical expenses plus $1 million. That's it. So if you're a 16, 17-year-old kid, and you're going to live another 60 years in a wheelchair, the government has said the most you can get is $1 million. It's a government set cap. Well, the Supreme Court has finally taken a case that's going to decide whether that cap violates the Tennessee Constitution. The Tennessee Constitution provides that every citizen has an inviolate right to a trial by jury, which by definition includes the right to have a jury rather than the government decide what your damages are. And the appeal says that when the government passed that cap, they invaded the right of common jurors, a jury of your peers, to decide what your damages are. So that's what the Supreme Court's going to decide, and we'll probably know sometime next spring whether those caps violate our Constitution.
The caps were put in place, I assume, by those lobbying who often get sued. Now, there were at times maybe absurd verdicts. You may disagree with me on that, but there were some. Everyone points to the crazy one where the woman got burned by hot coffee, and okay, whatever.
37 years ago.
I know. I'm just saying.
But I hear your point.
But I guess the point being is these caps were put in place, but I think you make an excellent point about, $1 million for someone there's a jury there for a reason to make these calls, right?
Exactly. We trust them to decide whether to sentence criminals to death. We can trust them to decide damages. But again, that's what the Constitution gives us. It's a small c conservative principle that we wanted. Our forefathers wanted jurors to decide what the amount of damages are, not the government.
And one other thing you've told me, though, is especially in this day and age, juries, in your opinion and what you've seen, are not always ready to just throw the cash at the plaintiff. I mean, oftentimes they side with the defendant because they're like, oh, well, you're complaining. I mean, why should you get any money for this?
It's just the opposite.
Yeah.
Nick. The incentive or the majority situation is jurors are finding in favor of hospitals, in favor of doctors, and making it harder for patients to get compensated. And I'll ask anyone that's watching this, when was the last time you read an article in a newspaper about a medical malpractice verdict in favor of a plaintiff or patient? You haven't. And there's a reason for that. These cases are almost always won by the doctors and hospitals.
Which just strikes me. I mean, jurors are a jury of our peers, and I've not been on a jury like this, but I would think if I'm sitting there, I would want to be as fair as I could to everyone involved, but I would try to put myself in the shoes of the patient. And if it was egregious, why do they not look at it that way?
Because you're going to put yourself in the shoes of the doctor.
I'm not some bazillion-dollar doctor who made I'm going to put myself in who I probably most relate with, which 99% of the time I'm going to most relate with the patient.
Jurors simply have a bias in favor of doctors and hospitals. They think that these people have a tough job, which they do. And because of that, they're willing to excuse mistakes that are made by them that they will not excuse by, say, a driver who rear ends you. Or some other type of, like a product liability case. They just have this sense of giving doctors and hospitals a lot of rope, a lot of leeway to do what they do. Look, it's proven. We've been living this for 25 years.
Right.
I mean, you can look at the stats. When plaintiffs only win 10% of these cases, you have to seriously wonder, is this built in to stone? And I believe that it is. I believe that's just the way it is. Part of my job, though, is to make sure I select the right case that can win. And if I do my job, then I have a case that I can also settle. And so one reason also why you're not seeing a lot of verdicts in the newspapers is because when the hospital or the doctor sees a case, they say, whoa, we screwed up. We caused some real serious harm here. You have a high likelihood of settling the case, and most of my cases settle.
Okay, and I think I'm glad you said that. So you're right. When it goes to trial, maybe that's the way it works out, where they side possibly with the hospital. But an awful lot of these cases, in the ones where there really are bad damages, the hospital knows it, the doctor knows it. They don't want the bad publicity.
Correct.
They don't want the headache. And if you're willing to negotiate with them to a fair, reasonable resolution, they're going to settle out of court, and we never hear about it. So it's not as though those injured don't sometimes win if they've been hurt. It's just you don't hear about it.
That's correct. I mean, I have a lot of cases against Vanderbilt. I've been handling Vanderbilt cases almost since the beginning of my career. I've had some large verdicts against them. I've also lost some cases to them. But the one thing I can say about Vanderbilt University Medical Center and their children's hospital is if you've got a good case, they will be reasonable in working it out in terms of a settlement.
They acknowledge it.
That's just how they operate. And so that's why I'm careful in selecting cases that I look at and I say to myself, first of all, can I help the patient? That's the number one thing. And secondly, if I can, do I believe it's a case that I can get settled? And if the defendant is Vanderbilt, I know enough about how they operate and their attorneys where I can generally get a good result for my client.
Because they are realists, and there are other maybe
and
hospitals
they care about their reputation.
And they care about their reputation, so they handle that. Real quick before we take our first break, because there may be some folks out there thinking, well, maybe I have a case, I'll think about it and I'll get back to you. This is real important. Why should you not put it off?
There's a statute of limitations in Tennessee of 1 year from the date that you discover your injury. 1 year. So if you discover your injury on December 1st of 2019 and you file your lawsuit or what we call send pre-suit notice December 2nd of 2020, you're barred by the statute of limitations. It's that simple. And there are a few exceptions, but the exceptions are rare, few and far between. So the bottom line is if you believe that you've been injured or a family member's been injured, seriously injured by a major medical mistake, pick up the phone, call me, call another malpractice lawyer, and get a consultation. It's free, it's confidential, and it can make the difference between you getting your day in court and not.
Yep. All right, look, as we go to the break, I know for a fact, sitting here with Clint in the past, when we've had calls, actually cases that he had an interest in where he thought the patient actually had a legitimate, complaint. And then we asked, when did it happen? And it was outside that year, meaning that you had a case, you didn't call, and that's over. You're done. And that's sad sometimes.
Well, it's sad because as a lawyer, you want everyone to have their day in court, and it hurts you when somebody can't bring their day in court because they waited too late.
Right. So we've seen it. So don't sit. Listen, we'll take a break. Some calls coming in. The number 737-7587. If you just have a question about the law or in general, obviously he knows that when it comes to medical malpractice. But also, if you or someone you know maybe has a question about something that happened with a doctor or a hospital, give us a call now. This is your chance. We can talk about it. We'll also talk about some other cases and what are some of them that you see coming through the door these days, and certain aspects of the medical profession bring more of this at different times. So we'll take a break, be back with more right after this.